you can't go to court, generally speaking, without an expert.
And an expert means a medical doctor for the most part, at least one.
At least one, but truthfully, a lot of times it involves 2, 3, 4 different experts. And all of those experts you have to pay. They're not willing to do that for free. So you're paying for sometimes 1 expert, 2 experts, 3 experts. Sometimes you need a expert that has to do with hospital protocols and are going to have to testify about whether they had the right protocols for treating the person that's injured.
Welcome to Bayou Justice, Breaking Victims, Protecting Power. I'm your host, Chip Wagar, a medical malpractice attorney dedicated to reforming Louisiana's healthcare laws. On this show, we dive deep into the challenges faced by patients in our state, exploring how current laws often favor institutions over individuals. Each episode will bring you compelling stories from victims, insights from legal experts, and perspectives from lawmakers. Join us as we work to shed light on these issues and push for meaningful change in the Bayou State.
Hello, everybody. I'm Chip Wagar, and welcome to Bayou Justice, Breaking Victims and Protecting Power, a program of the Patient Rights Advocacy Forum here in Louisiana. And my guest today here is an old friend, Allan Berger. I want to introduce him to you. I would say, and he won't say it, but I'll say it, he's pretty much one of the deans of personal injury practice here in New Orleans. He graduated from Loyola in 1974 and has been practicing since 1975 with his firm, Berger and Associates. He's won innumerable awards: Best Lawyers in Louisiana, Super Lawyers, New Orleans Magazine, Top Lawyer, Best Lawyers in America. Allan, welcome to the show. It's so good to have you here.
Thank you. But obviously, I'm still learning all the stuff, too, that we need to learn.
Well, let's talk a little bit about medical malpractice. Let me start off by just asking you, if your firm handles all kinds of personal injuries, not just medical malpractice.
Correct.
Is that right?
Auto, medical malpractice, pharmaceutical cases that you hear, medical device cases, hip, knees, all of that stuff, where the products have gone bad and then we are involved in it.
So tell us a little bit about how your first medical malpractice case, how you got interested in doing medical malpractice in Louisiana. It was a long time ago. Tell us a little bit about that.
Okay. I started back in 1974. I graduated Loyola Law School. 75, I came out, and a family came to me, and they said that their son had been in a motorcycle accident. And when he was in the motorcycle accident, he had to go to one of the hospitals, the local hospitals, and anesthesia was not performed correctly. So he ended up brain damaged. And I figured at that time that I got to make a choice. Now, at that time, believe it or not, there was no cap in Louisiana. They hadn't done the cap. It was a few months before they started the cap in Louisiana, the limitation where you can't recover more than the $500,000, which I'm sure we'll talk about later on. But anyway, that's how I got started, and we had a good result. And I said, you know what? There's got to be somebody that also protects the people that are injured from medical malpractice. And we, like I said, had a good result. And I've been doing it ever since.
You've been doing it ever since. But not a lot of personal injury lawyers do medical malpractice, do they?
No, they don't.
And why is that?
Medical malpractice, since they've developed the limitation that you can't recover like you can in an automobile accident. If you're in an automobile accident and you're severely injured, brain damage, loss of a limb, anything like
that,
paralyzed from part of your body, there is no limitation on what you can recover. In medical malpractice, there is a limitation, and the limitation is $500,000. Now, out of that $500,000 for your pain and suffering, now we're talking about a pain and suffering award, out of that $500,000, attorney's fees have to come out of that, but the attorney has to spend anywhere from $30,000 to $50,000 or more, if it should go to trial, to acquire the experts to say whether or not the doctor or nurse or hospital did anything wrong. And that's a big expense. And so most people don't want to put out that it's not an easy number to put out for attorneys on a case that is whether or not they're going to recover or not. And a lot of times, as you can imagine, doctors don't want to testify against other doctors locally. So you have to sometimes go out of state to get a person in that specialty to come in and say what the real deal is.
And so for an attorney anyway, it's a big expense to handle a medical malpractice lawsuit. Is that right?
Absolutely. Time commitment and money expense.
Time commitment. I mean, for a case that goes to trial, how many hours would you say?
Untold. Immeasurable, because you've gone through already 2 to 3, 4 years of working the case constantly, and then on trial for the last 6 months before trial, you're just constantly on that case and working it.
And people who serve on juries, they in a personal injury case, let's say an automobile accident, they pretty much know the law, right? They know it's a rear end. If you crash into somebody from behind or you run a red light, you don't have to tell
Common
people.
sense. Common sense just tells you what the story is on automobile accident for the most part, unless it's a really complicated type of case. But for the most part, most people know what the story is in an automobile accident. It's just a question of, generally speaking, how badly was that person hurt.
But it's a little different in medical malpractice, isn't it?
Totally. And that's why another reason why a lot of people do not want to do medical malpractice. It takes an incredible amount of hours as an attorney to have to study to realize what happened in that medical situation that you're handling. It's not something that you just pick up a book and say, after an hour, you know what the situation is.
Now, in an automobile case, rear end collision, run a red light kind of thing, you don't usually need to hire experts or anything to make the case.
No. Usually it's a red light. He didn't have the red light, or she didn't stop before she hit him in the rear, or one of those types of cases. Occasionally you do need an accident reconstruction expert. That's occasionally when it's contested and it's all about the accident versus the damages.
But medical malpractice,
you can't go to court, generally speaking, without an expert.
And an expert means a medical doctor for the most part, at least one.
At least one, but truthfully, a lot of times it involves 2, 3, 4 different experts. And all of those experts you have to pay. They're not willing to do that for free. So you're paying for sometimes 1 expert, 2 experts, 3 experts. Sometimes you need an expert that has to do with hospital protocols and are going to have to testify about whether they had the right protocols for treating the person that's injured.
So medical malpractice lawsuits are expensive for an attorney to handle.
Correct.
And after you take out attorney's fees, contingency fees, expenses, and so forth, it doesn't leave a lot for the victim, does it?
It doesn't. If the victim comes out with half of what there's the cap of $500,000 on pain and suffering, no matter whether you've had a stroke, like I said, or whether you've had amputations, or whether you're brain damaged, or whatever. And that's the way that the legislature passed the law way back when.
When you started practicing.
That's correct. When I started practicing, they actually didn't have a cap, but it
But
came in
1975.
That's right. But 1975, the cap came in. And they've had challenges to it, and none of them have been to the point where they overturned the cap. The legislature has not really attempted to change that $500,000, other than at one point in time they did actually add that you could get future medicals. At the beginning stages, you couldn't even get future medicals.
And we've talked about the $500,000 cap, but what about the nursing home or the hospital that has caused a catastrophic injury and has been found to be negligent, to have, a jury finds them to have committed malpractice and the result is a catastrophic injury? How much does the actual wrongdoer have to pay? What's the maximum in Louisiana?
Interesting, because most people have no idea about this, but the doctor, hospital, nurse, whatever it is that caused the injury, has $100,000 is all that they have to carry a policy for, either a policy or a bond of $125,000. That's all that they're responsible for. After that, the patient compensation fund, Louisiana Patient Compensation Fund, that all medical personnel contribute to if they want to be protected by it, comes in for the other $400,000.
People talk about Louisiana's trifecta, the caps that you've talked about. There's also a medical review panel process that a victim has to go through before they can ever even file a lawsuit.
Correct.
And then if they do recover damages, if they prove negligence and malpractice on the part of the hospital or nursing home, whatever it may be, Future Medical is not, they don't get Future Medical in a lump sum. It's given to a government agency in Baton Rouge who doles it out. Correct. After that, right?
Right. So what happens with Future Medical is this. Let's say you go to a jury trial and the jury says, yes, they were negligent, and it's more than $500,000. So that $500,000 you get, that's an award. And they say that you're entitled because of your injuries and everything, that you're also going to have future medicals.
Like brain damage or paralysis.
Stroke, paralysis, amputations.
Baby cases where they're going to have to be taken care of for the rest of their lives.
Correct. All that is paid by the Patient Compensation Fund. It's not paid in a lump sum. Let's say that a jury gives you they put it on the judgment that they issue of $10 million it's going to take to cover this person's medical
for the rest of their life.
Could be $20 million. But let's say that they say it's going to cost $10 million to cover this person. The Patient Compensation Fund only has to pay that out on an as incurred basis. So when they'll give you a card, when you go to the physician or the hospital, because you have to go back to the hospital again and stuff like that, they'll give you a card that you'll present to that medical professional, and that's paid on as incurred basis. Now, to be fair, I will say that the Patient Compensation Fund sometimes does not want to do that because it's a lot of time and expense on their part also. So occasionally they will say, let us know what total sum that we can pay to clear this case completely. But they work off of workers' comp numbers, which are much lower than what is generally charged.
So when it comes to your medical care or your loved one's medical care for the rest of their lives, after you've proved medical malpractice, what gets paid and what gets covered and how your medical care is managed lies with the government, not with the victim or his family.
Correct. The $500,000 must be paid. The past medicals that were incurred up until the point where you reach the final jury decision is paid. But anything in the future, you're relying on them to say, okay, we agree. But they have a right also to have a doctor come in and say, we don't agree that this is really necessary for this future treatment or that future
So they
treatment.
can dispute and not pay if they deem it not to be reasonable or necessary.
That is correct. That is correct.
Okay. Do you think most people think that they're capable of managing their own medical care versus having the government do it?
It's, that's a hard one because there are some people that have family members that are all over what medical care is needed. And then there's other situations where, no, the person's on their own, even though they've suffered all these injuries and stuff. So,
but the court doesn't make any distinction between those who are capable and those who are not. It's
No.
not allowed for any medical malpractice victim. The government decides what they will pay for and what they won't.
That's correct. They can contest any charge that you say is necessary.
Now, I've read that there's only one other state in the whole United States that has that system, this trifecta system, and that's Indiana, I believe.
Which is what I believe, if I'm not mistaken, Louisiana's law was based on.
And I understand that they raised the medical malpractice caps a long time ago.
Correct.
To, $1 million or more in various categories.
Right.
But
They
no
found
other
it
state has that.
insufficient. Yeah, that $500,000 cap was raised because it was insufficient.
Well, what about other southern states? Do they have these caps and trifecta like Louisiana?
Some tried to put it in, and the courts refused it. I can give you examples of Georgia threw it out, the cap of $500,000 or any of the caps. They threw that case out as unconstitutional. The cap. Georgia, Florida threw their cap out because they found it unconstitutional. There are other states that haven't put in. They've maybe tried. They've been thrown out also. If I'm not mistaken, Arkansas has no cap. Oklahoma has no cap.
Alabama, I don't
Alabama, I don't believe has any. Kentucky has no cap. Kansas. I mean, a lot of them have thrown these caps out because they found them unconstitutional. Because what you have to realize is that a person who's in an automobile accident or a construction accident gets whatever it takes. If the jury
full
says,
and fair compensation.
Yeah, if the jury says that in this case you were negligent and the person was negligent that wasn't injured, and the injured party is able to recover everything, anything. It can be whatever it is. Imagine what it takes if you're brain damaged. Imagine the medical expenses today. If you were brain damaged, what it would take to care for you and the treatments that you would need, all of that. Well, in Louisiana, that cap sits, and so they can award you for the physical pain and suffering, whatever. If you have no cap, they can award you like they do in an automobile case. They can award you whatever it takes or what the physical pain and suffering will be. When you have a cap like that, there's nothing you can do. I mean, other than we've gone to the courts before, and they haven't thrown the cap out. The legislature,
like other states have done.
Yeah, and the legislature hasn't budged on it. The medical profession tells the legislature that, look, if you take this, if you pass something that takes this cap off, then we're not going to have doctors in Louisiana. It's that simple. But that's so untrue.
That true?
No, it's so untrue, and I'll give you an example. There are Midwestern states that I'm going to have to repeat: North Dakota, Iowa, Kansas, states that have a cap, okay? And they're having trouble getting doctors in those states. Whereas Illinois, another Midwestern state,
a big
Midwestern state,
Chicago,
has no caps. And they have sufficient doctors in all their, especially like OBGYNs, which is a high-risk profession. They have plenty of doctors. So it doesn't make sense that because it just doesn't make sense of what's going on, because the caps are not making it so that doctors are sufficient galore in these states that have them.
Why was this? You were around in 1975.
I was.
Why
Bailey,
did Louisiana?
Bailey. I don't want to admit that, but Bailey.
All right. Why did the Louisiana legislature pass this law in the first place?
Because they, number one, the medical profession said that if there's not a cap, doctors are going to leave the state.
Why?
That's all. They felt like there was another part to it too, but because they felt like they wanted the cap, it restricted the ability to get if somebody was brain damaged or a baby was born brain damaged. They waited too long to do the cesarean section. Whatever it might be. Okay, amputations. I've handled cases where people have been amputated 4 limbs, all 4 limbs. I've also had them amputate 3 limbs where I've had to handle the case, and it was all very bad medicine. Let's just say that. one to the point where one of the doctors from another facility said, if you don't get this person over here right away, I'm going to call the police and tell them to go get the ambulance and get them from there. But anyway, they gave two reasons. One, doctors will leave, and the second is our rates for insurance, our malpractice insurance is going to go crazy.
So insurance costs, liability insurance costs, was supposed to be controlled by these draconian caps and trifecta that we talked about.
That's correct.
But I have read, statistically speaking, that at the time in 1975 we had an insurance commissioner, and his name was Sherman Hodge. Do you remember Sherman Hodge?
I barely remember. I kind of.
Well, he testified on April 10th, 1975, before the Louisiana Legislature subcommittee that was considering doing this act. And he testified under oath at that time, as the insurance commissioner, that the cost of Louisiana's liability insurance premiums for doctors and so forth was 25th in the nation, right about dead center.
Okay.
According to statistics, 30 years after that, by 2005, Louisiana had the 17th highest insurance,
and we had a cap
in the
at
nation
that time, right?
We have a
cap
cap.
was in
We've had a cap for
existence, so
30
it's going
years,
up even
and
with
it's
the cap.
and it's 17th, and then 50 years in, which is kind of around where we are now, according to the Cunningham Group, which is a national insurance brokerage firm for doctors and hospitals and so forth, Louisiana has the 8th highest medical insurance premiums in the nation. What do you think about that? Didn't work too well, did it?
Looks like the reverse is happening. They thought that they were going to hold down prices, and insurance prices here have just obviously going up.
Here's another statistic I found, and you can look this up on the Louisiana Patient Compensation Fund website, their annual report for 2024 for last year. Between 1990 and 2010, so that's a 20-year period. Surcharge, what they charge on top of medical insurance to the doctors, to the hospitals, nursing homes, and so forth. The surcharge rates on malpractice insurance paid to the PCF increased by 540%. Now, in that same period, you look this up, the Consumer Price Index, inflation was 75% during that 20-year period. Mm-hmm. Yeah.
It doesn't make sense, Chip. It does not make sense.
And what is the cost? Who pays the price for this?
I mean, the person who's injured, because there's a cap and there's no ability to get over the cap. And think about this. I want you to think about something else, too. It's not just, although the person injured is put into a bad situation, what about the family that has to stop jobs and work to take care of the injured party? What about that? You have to give up more than just the life of the person that's badly injured, that's not compensated completely, and the family has to find a way to handle the injured party. So it doesn't make sense. The arguments to have caps don't make sense because you've shown from the statistics that even though you have caps, the insurance rates still went up here in Louisiana. Way up. I mean, yeah, unbelievable. The fact that doctors would leave, that doesn't make sense because obviously there's articles written that the states that have caps, the doctors, there's not, there's sufficient doctors. The whole situation doesn't make sense. And one last thing that we got to talk about real quick is it was sold on the basis that there was an insurance crisis, that these cases were costing all this money and everything like that. But it's been proven over and over by people within the insurance industry that it has to do with investments by the insurance industry that make those rates go up and down. Not how much they're paying out in medical malpractice or anything like that, or that might that might be one element, but a lot of the element is the investments that the insurance companies make. And if it's a downtime, they want to make up what they lost. So what are they going to do? Raise rates.
Now, sometimes we handle different cases in medical malpractice, and sometimes the injuries are worse than others. People who have, and I don't want to minimize anyone's injury, but there are a lot of injuries that the cap or the absence of the cap wouldn't make much difference.
Correct.
So, but the other side of the coin is, for catastrophically injured people, this is where the law really bites, doesn't it?
Yeah, it really does, because they're left out. It's that group that really doesn't have a way to complete their recovery. But with you saying that, I want to bring up one last thing. Let's say that you're in your 20s, your 30s, your 40s, your 50s, and you're making a good wage, okay?
You're productive.
You're productive, or you own your own business, and it's a good business, and you're making some money, and you get hurt from medical malpractice, okay? Unless your lost wages number is in that $500,000, you're not getting your lost wages on top of that $500,000.
So if you're permanently injured now, you cannot work anymore. You're totally disabled. The Medical Malpractice Act makes no provision for
lost wages separate from the $500,000. No, it does not.
Now, two adjoining states, Texas and Mississippi, and I practice in both of those, and you probably handle some cases over. Texas and Mississippi do have a Medical Malpractice Act, but they don't cap loss of earnings.
I think that's all outside of the
That's
cap.
outside of the cap.
Yeah.
Okay.
You know that better than I do.
Yes,
but,
yes.
But yes. I think
And
it
so
is.
Louisiana's Medical Malpractice Act makes no allowance for that. That's all within the cap. And if your lifetime of earnings for your 20 or 30-year-old person over the course of a lifetime could be in seven figures. You could make more than $1 million over your whole lifetime and so forth. All that's included in that hard cap.
That's the $500,000.
$500,000.
Yeah, absolutely.
So, what impact does this have then on the taxpayer? I mean, what impact does this have on Social Security, disability, Medicaid, Medicare? Who pays for that?
You just said it. Medicaid,
I do.
All the people that contribute to funds and Medicaid ends up having to pay for a lot of that stuff. Yeah, I mean it's
and the
back
wrongdoer,
on the taxpayer.
The wrongdoer, $100,000, and that's it.
That's correct. They pay for a policy of insurance for $100,000, or they can post a bond for $125,000 in Baton Rouge. But that's their obligation only. So if you're injured, that's all the doctor, the hospital, whatever it is that caused your negligence in the medical profession, that's all their responsibility is.
And let's be frank about this. Some of these institutions are multi-billion-dollar enterprises now.
Oh, absolutely.
I think Ochsner's, for example, the largest in Louisiana, last I looked, their revenues were over $4 billion a year.
It should be, probably.
Yeah.
Very close to that. Yeah.
You decided to get involved in the Patient Rights Advocacy Forum back in 2021, and you're a board member. Why'd you do that, and what do you want people and legislators to know?
The reason why I joined was because I feel like it's a great organization to get the word out. It really is. And if you asked me right now, how many people know that there is in Louisiana, if you're severely injured, or even, you don't have to even be severely injured or killed or whatever, that they know that there's a $500,000 cap.
And a $100,000 cap on the wrongdoer.
Right. But $500,000 is all they can get. And they're not getting the $500,000 because, remember, attorney's fees and expenses for those experts have to be taken out of that. okay? I don't even think that many legislators know that there's a $500,000 cap.
And that's
Until-
$1975.
That's correct.
And inflation since 1975's, I think, around 452% or something.
Yeah.
It would be worth, that $500,000 cap today, I think, would be worth $2.75 million in today's dollars.
That's correct, and which brings me to a point. That's why a lot of the states that did even have caps, that do even have caps, have now. California just did this.
Indiana.
And now they have gone back to the legislature and they have raised the limits of those original caps. Because think about it, 1975, what did you pay for gas? What did you pay? I wish I had those numbers because it would be unbelievable if you realized what you paid for groceries.
And who would want to be paid today a salary in $1975?
That's what you're basically asking, is that please take what you would have, $1975 would have paid.
So what would you like people, what would you like the legislature to know about this? You really can't get full and fair compensation, badly injured medical malpractice victims in Louisiana. Really, the system doesn't allow for full and fair compensation, does it?
I don't believe it does. I believe that the juries know and hear cases. They know what the value of a case is. And I know a lot of people say, yeah, but that jury gave such and such. When you consider the cost, just think about, I'd like you to go back and think about what the cost was to go to a doctor back in 1975, okay? And when you think about what medical costs have gone up to today, okay, it's just an unfair situation, and the legislature should change it. And if they don't change it to where it's increased drastically, and my belief is the juries know best, because after hearing a whole case and what went on and everything, I think that the cap should be thrown out. But the second part of it is that if the courts don't throw it out as unconstitutional, as many states have, okay, then I think the legislature needs to change it and increase the amounts and take into consideration that this act was passed in 1975 and those numbers were given based in 1975, and we are now in 2025.
And maybe put a cost of living provision in it too, so that they don't have to keep going back, that it just keeps pace with inflation.
That, and number two, I think that the issue of lost wages that many states that do have caps have put over and above the cap that you can recover, okay, that's that needs to be added also. That, your economic loss should also be on top of any physical pain and suffering recovery that you're entitled to.
So you're not a burden on the taxpayer. You're not a burden on your family. You have full and fair compensation.
Correct.
Allan, it's so great to see you again and to spend time with you discussing this topic. Thank you so much for spending time with us today and helping us get the word out as to how brutal and cruel Louisiana's medical malpractice system really is.
Yeah, it's restrictive. So many people don't know about it. Like I said before, even if you were to go down the legislators and ask them, did you know that all you can get in Louisiana under medical malpractice is this, this, and this? Lots of them wouldn't even know that.
Well, let's hope we can change that.
I hope so. And
Thank
I know
you.
you'll work hard, and we'll keep working hard. All of us working hard. We'll get the message out that y'all have really done a good job on.
So, Allan, you and your firm handle, we've already covered medical malpractice. If someone wants to get in touch with you or your firm, if they have a medical malpractice claim, how can they do that?
Simple. 504-526-2222. That's all. Easy to call.
Thank you. For those of you who'd like to learn more about this subject, please visit our website, which is patientrightsla.com. And there's a lot of information on there, and there's ways you can help, because Most people don't know about medical malpractice until it happens to them, and then it's too late. The law is what you will find out what the law is and how your rights have been taken away while you were living your life and not paying attention to the subject. We need to do something about this now. Thank you for watching.
Thank you for listening to Bayou Justice. I hope today's episode has given you valuable insights into the complexities of medical malpractice in Louisiana. If you'd like to learn more about our mission or get involved in our advocacy efforts, please visit patientrightsla.com. Your support can make a real difference in the lives of patients across our state. Remember, together we can create a fairer, more just healthcare system for all Louisianians. This is Chip Wagar, and I'll see you next time on Bayou Justice.